Popovski speaking. Am I audible?
Yes, sir.
Yes, Professor.
We can hear you clearly.
Thank you, Giuditta, for joining the series of lectures organized by the Center for the Study of United Nations, which I direct, and the Jindal Society for International Law, which Ankit Malhotra probably already presented to you. It's a high honor and a privilege to have you with us. As Ankit mentioned, it's really an excellent distinguished speakers series. And I think we were very lucky to have everyone. Because of the COVID-19, people probably easier accept commitments without travel, without hotels, airports, and all of that. And that makes our students very happy, because they are really privileged to hear from top international law experts around the world, as we have today with Professor Giuditta Cordero-Moss. Brief introduction. She's a professor at the University of Oslo with the field of expertise primarily in private international law, Norwegian and comparative law of obligations, international commercial law, commercial arbitration. Giuditta is often invited by universities and organizations, including the Hague Academy of International Law, where she held a series of lectures on Party Autonomy in international commercial arbitration. Also appointed elected member of numerous organizations, among those the European Group for Private International Law, the International Academy of Comparative Law, and the Norwegian Academy of Science and Letters. Since 2017, Professor Cordero-Moss is a president of the Administrative Tribunal and at the European Bank for Reconstruction and Development in London, where she has been a judge since 2007. So our pleasure and privilege again to have such a distinguished speaker today on the topic of fragmentation and fertilization of international law. So we are very curious to hear on something probably we discussed in previous occasions with other speakers. What are the advantages and disadvantages of the development of international law in a very globalized and diversified world where we have so many jurisdictions and so many developments, domestic and international, and how we can assess the development of international law in time of globalization, but also fragmentation and fertilization. So as usual, we will give the speaker all her time she needs. We have actually time of 90 minutes, and we have students already in the classroom. So I would suggest to start without further ado, your time, Giuditta, for your presentation, and I will moderate the question time afterwards. Thank you.
Thank you very much, and thank you very much for the invitation. It is my honor, and I was impressed by the by how the program, how extensive it is, and it is really a very rich program. I'm happy for the students who can take advantage of that. So I will be talking about fragmentation and cross-fertilization of international law, which is a topic that has been, particularly the fragmentation, has been a very topical issue to discuss in the last decades, I would say. And this is actually a consequence of the development of international law. I have here, just to put it in a graphic way, I'm showing how many different branches there are in the international law, and this is only a list that is, it's not exhaustive at all. There are many other examples, so you can see that here I have ... law to as a symbol of the fact that there may be many other different laws. And the point is that often these different branches of the law, they develop as if they were some self-contained regimes, so as if they were independent from each other, although they all are part of the international law. As you can see from the drawing, the big blue bubble within which all these colored bubbles exist, it's the container of the public international law. And then there are these self-contained regimes that exist and develop on the basis of their own assumptions, without necessarily taking into consideration the circumstance that they are only a part of a larger system, the system of the public international law. And this is actually the whole point of the fragmentation, that you have originally, in principle, a unitary system of the public international law, but then it is fragmented by the development of these self-contained regimes. And the question of the cross-fertilization is, of course, a question whether it would be possible or advisable to cross-fertilize among these self-contained regimes. So principles and values and mechanisms that have been developed under one regime, could they be useful? Could they be adopted in a different regime? So you have the fragmentation on the one hand that renders possible, possibly, the cross-fertilization on the other hand. And what I'm going to do today, I'm going to talk about two of these branches to show the two opposite approaches. In one case, I will make the point that cross-fertilization is advisable, and in another case, I will make the point that cross-fertilization is not advisable. So I wanted to show that, that there is not one single approach, one single correct answer, but it depends on the different situations. So what I'm going to look at is the international administrative law. As was said at the beginning, I have been actually until 2020 a judge, and for some years also the president of the Administrative Tribunal of the EBRD. So I'm going to make an example from that experience to show how the cross-fertilization could be useful. And then I'm going to make an example on international commercial law, which is not necessarily public international law, but I'm going there to show the borders and the pitfalls that exist in considering international commercial law as part of the public international system, as it sometimes is. So these are the two points that I'm going to make. And of course, I have already started talking about the substance, whereas I had one more slide that wanted to show the fragmentation, the proliferation of courts. Not only we have all these colored bubbles that we just saw that are a symbol of different regimes that develop on their own assumptions. Not only do we have different regimes, we also have different courts that, of course, enhance the impression that they are separate, self-contained regimes. So this list here is a list that I have made in connection with a different project. I am working as the general reporter for one section of the Congress of the Academy, International Academy of Comparative Law. They will have a congress in a couple of years' time in, I think it is in Paraguay. And one of the topics is independence and impartiality of international adjudicators. That's the topic that I'm being the general reporter for. And writing the questionnaires for that work, I have compiled this list of international courts that is not exhaustive, of course, but it is probably the most important courts, international courts that we have today. And you can see from the list that is really a lot of many different courts. And this is only enhancing the previous drawing that was showing all the different colors and the fragmentation that you have within the international, the public international law. So here I have a reference to the International Law Commission that, as you know, is a body that has, it's a relatively controversial body. But it has existed for many decades, and it has the task of preparing documents which are supposed to give clarity on different aspects of the international law. And in 2006, they have published a report on the fragmentation of international law. And they have also published some conclusions on this work. I think it was 42 conclusions, if I don't remember wrongly. This is only one example of the documents that have been made on the issue of fragmentation. And we will come back to some of the recommendations or the conclusions that have been made by the ILC on the issue of fragmentation, to show that there is not, as I said already, one single answer to the question of how to deal with the fragmentation. So I told you that to exemplify this issue, I would make two examples, and I will start with the first example, which is when cross-fertilization is desirable. So when it is desirable to pick elements or sources or mechanism, either from one of the other colors that we saw on the first slide, one of the other areas of the public international law, or from the method of the general method of the public international law, which all these self-contained regimes are part of. And as I already mentioned you, this example is going to be based on the Administrative Tribunal of the EBRD. The Administrative Tribunal of the EBRD is, first of all, let me say what the EBRD is very, very quickly. European Bank of Reconstruction and Development. The European Bank of Reconstruction and Development was founded at the beginning of the 90s as a consequence of the changes that followed the collapse of the Soviet Union. What you see here is the wall in Berlin, and that's the end of 1989, when the wall was actually torn down, and you have people who could suddenly go freely from the east to the west of Germany. So this was historically a very, very important occurrence. And what happened, among other things, was that an international bank was established, like more or less like the World Bank, but with the purpose of helping the reconstruction and development of the former Soviet Union, Eastern Europe, and then it was a little bit expanded after that. So this is what the EBRD is. So the EBRD is an international organization, just like the World Bank. And these are the documents that constitute the EBRD. Among other things, these statutes and these international conventions that establish the EBRD, they provide for immunity. International organizations have many different kinds of immunity. And if you look at the headquarters agreement of the EBRD, which is one of the documents that establish the EBRD, you will see that is an agreement between the EBRD and the United Kingdom, because that's where the seat of the EBRD is. Among other things, this headquarters agreement says in Article 4 that the EBRD, as an international organization, has immunity from judicial proceedings. So within the scope of its official activities, the bank shall enjoy immunity. And there are some exceptions, but they are not interesting to this particular topic here. So the bank has immunity. Okay, that we understand. Then, of course, we have to look at the other side of the coin. The bank has immunity because it is an international organization. It may need immunity to enhance this international aspect. That is good. But we also have the other side, which is that, for example, under the European Convention of Human Rights, Article 6, everyone is entitled to a fair and public hearing. So everyone who has a claim against the EBRD, in theory, should be able to present this claim under the Convention of Human Rights. However, we have the immunity. How do we do that? How do we reconcile this contradiction? And this is something that has not been invented for the EBRD. This is something that has existed for many decades. The solution to this dilemma here lies in the establishment of the so-called International Administrative Tribunals. International Administrative Tribunals, they are, I have here a list which shows that they can be found, this is the World Bank, this is the United Nations, this is the IMF, the ILO, and so on and so forth. And also the EBRD has one International Administrative Tribunal. What is the scope of jurisdiction of these tribunals? It is to decide disputes between the employees of the international organization and the international organization itself. Why? Because since the organization has immunity, if you are an employee working, for example, in London, in the offices of the EBRD, and you have a claim against your employer, you cannot go to court because there is immunity. However, you have a human right to go to court, and which is not necessarily the national courts because you have immunity. It is a special purpose court that has been established, an international court, an international administrative tribunal, like those that you have here on the list. So this was the solution to permitting to have access to court while at the same time respecting the immunity of the bank. And the administrative tribunal has a relatively complicated, actually, set of rules on procedures and appeals and how it works. We won't go through all of this because we don't really need that for the purpose here, but they are all available. If you look very hard, you will find them all on the website of the EBRD. Among other things, there is a directive on appeals process that says in section 2.1, right of appeal, and it says a staff member may submit an appeal against an administrative decision to the tribunal, blah, 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 blah. Everything else is not so relevant here. What I wanted to focus on here is that the administrative tribunal is there for a staff member or a former staff member. So the point is that you have to be an employee for the purpose of presenting a claim before the administrative tribunal. And this we can park in the back of our head because we are going to need this knowledge. We are going to come back to that. Then there are rules on the applicable law. What law shall the administrative tribunal apply? And in considering an appeal, the tribunal shall base its decision on the provision of the staff member's contract of employment, on the internal law of the bank, and generally recognized principles of international administrative law. Okay, so these are the sources that are applied by the administrative tribunal. We will also come back to this notion here because we will need that for our reasoning. So our reasoning is based on a decision taken by the administrative tribunal in 2019. This is public. If you go to the, if you Google EBRD AT, the EBRD AT, that's EBRD Administrative Tribunal. If you Google EBRD AT, you will quite quickly come to the homepage of the Administrative Tribunal. And there you will have links to all the decisions that have been taken because they are public. So I'm not infringing any rules or laws or anything in showing this to you. It is fully available on the internet. So this is a decision that was taken, and I was the chair of the panel there, and the panel was consisting of 3 judges. And that decision there was taken on this background here. Now you can see that it's the inverted chronological order here. So the oldest thing is on the bottom and the newest thing is on the top. Why? Because that decision was a decision taken on the appeal that the appellant had made against the part. The part is the President's administrative review decision. So it was a decision on this particular appeal. And the appeal was based on all these other decisions that had come earlier. To put it shortly, there was a person who had been working for the EBRD for many, many, many years. However, not as a formal employee, but as a consultant. I think it was, there were more of these cases, so I may be confusing, but I think this one was in the field of information technology. So it was an IT consultant who had established his own single-purpose company. And this company, now I hope I'm not confusing with some other cases, but it's not very important in the details in any case. The company had entered into a contract with an agent, and the agent had entered into a contract with the EBRD. I think it was more or less something like that. And the point was that he was working as an independent consultant to the EBRD, consulting to the EBRD, and he was not an employee in a formal way. There was no agreement of employment between the bank and the consultant. However, he worked for the EBRD for many, many, many years, only for the EBRD, and he was full-time working for the bank, subject to the instructions by the bank and treated as if he was an employee, only he was not an employee. So the question was then, when he, after many, many years, received information that his contract would be terminated, he said, but I want to be treated as an employee, and I want to have the severance, the payment of a severance upon termination of my contract. And the bank said, no, you are not an employee, so you are not entitled to severance. And he said, well, I am de facto an employee, not in form, but in fact. And the question was, does the Administrative Tribunal have jurisdiction on a situation like that? You remember that I showed you the jurisdiction, the power of the tribunal is limited to staff members. And this one was not a staff member. He was someone who claimed to have been a staff member, but there was no formal letter of employment. So here the question is, does the power or the jurisdiction of the tribunal rely on the form, on the label, are you formally an employee or not? Or does it rely on the substance, on the reality? I was not formally an employee, but I was treated as one, and I was in fact one employee. So this was the question, and this is a very controversial question. Even within the Administrative Tribunal of the EBRD, it was controversial. There were 5 or 6 cases on that, which all had dissents because there was no unitary understanding of the law in this particular case. But in any case, this particular case here had already been decided in 2018. In 2018, the Administrative Tribunal decided that the tribunal had the power to listen, to hear the claim. Of course, the tribunal would need first to decide whether this appellant was an employee. And if he was not an employee, then there would be no jurisdiction. But if he was an employee, then there would be a jurisdiction. So this is the basis for the decision that we are looking at now. The Administrative Tribunal decided we can hear the case, so we can hear whether and decide whether this one was an employee or not. And then the case went through the internal administrative review system, went up to the president, who refused to consider this person as an employee, and this was the question, the decision that was appealed. So this was the decision that we are looking at now. So the jurisdiction was based on, well, this is actually just a summary of what I told you. The contract between the appellant and the bank said nothing contained in these conditions or in the contract shall be construed as establishing or creating any relationship other than that of independent contractor between the bank and the agent. So there was obviously no formal employment agreement. And the Directive on Appeals says that the tribunal only has jurisdiction when there is a staff member, so when there is a contract of employment. The decision in 2018 said that allegations that the staff member rights have been infringed fall within the jurisdiction of the tribunal. When the evaluation of whether a staff member rights have been infringed assumes as an incidental question that a decision is made on whether the appellant was a staff member, it falls within the jurisdiction of the Administrative Tribunal to determine whether the appellant was a staff member or not. So this is the assumption of the decision that we are going to look at now. And this is what I told you is still a very controversial matter, even within the Administrative Tribunal of the EBRD. So the decision that we are looking at now started first by recalling this history about the jurisdiction, and then continued by looking at what is the applicable law that the tribunal has to apply. So these 631, 632, and so on, they are references to the sections of the decision that we are examining now. So the Administrative Tribunal had to decide whether the appellant was an employee or not. And in order to be able to make this decision, the Administrative Tribunal had to apply a law. And we have seen earlier which law has to be applied by the Administrative Tribunal. We have seen it in the constituent documents of the Administrative Tribunal. It was the staff member's contract of employment. It was the internal law of the bank, which comprises the staff regulations and the bank administrative practice. And it was generally recognized principles of international administrative law. And it is in the connection with this last issue, generally recognized principles, that the cross-fertilization could be very useful. So the decision, after having looked at the contract and after having looked at the internal law of the bank, started looking at the generally recognized principles of international administrative law, not of public international law, but of international administrative law. Here we had a discussion because international administrative law could be seen as a self-contained regime that has its own generally recognized principles and that is completely isolated by the rest of the public international law, or it could be seen as one of many colored small bubbles in the larger container of the public international law, as we have seen in the first slide. And what the decision says is that generally recognized principles can be seen as a parallel within the borders of what is administrative law. It can be seen as a parallel of the source that we know from the Article 38 of the statutes of the ICJ, which is one of the sources of the public international law. So this legitimates looking at what has been said and done and written in connection with Article 38 for the purpose of getting inspiration as to what is the method for finding out whether you have a generally recognized principle or not. Knowing and keeping in mind that the ICJ regards the public international law as such, and not necessarily the international administrative law. So whatever we see in the literature and case law relating to the principles in public international law can be applied analogically also to the to the international administrative law, to the extent that these two regimes are compatible, of course. So there is no automatic effect. We have to find out what are the principles that have been developed in connection with the public international law, and could they be applied correspondingly also in the international administrative law. So you have to make this sort of assessment. There is no automatic effect. And in order to understand what how the Article 38 of the ICJ is interpreted, how it works, what is that mechanism, the decision that we are analyzing here now looks at what was at the time a very, very new, it was the absolutely latest source available, the first report on general principles of law, adopted by the 71st session of 2019 by the Commission. And what they made reference to there, it was generally recognized principles. They can be principles that are formed within the international legal system, or they could be principles that are derived from national legal system. So they make this distinction here. And this distinction was followed also in the decision that we are analyzing now. Let's first look at the principles that are formed within the international legal system. What is the international legal system? Well, you know that better than I. It's treaties, it's custom. It can very well also be jurisprudence by other comparable international courts. Comparable international courts. And here was another issue of discussion internally, because what are comparable international courts? Of course, I showed you the list of all the administrative tribunals that exist. And they are comparable courts, of course. So the jurisprudence of other administrative tribunals, that is important. But does that mean that the jurisprudence of other international courts would be completely irrelevant? I don't think so. Now, there was no jurisprudence particularly directly on this point, but in my opinion, a comparable court, international court, could be also the European Court of Human Rights, for example, or it could be some other court, to the extent the decision that you want to compare is rendered in a case that responds to interests that are present also in the area that you are comparing from. So there is no exclusive field only for international administrative tribunals. However, if you look at the jurisprudence of international administrative tribunals, you will find that it's always only case law from the other administrative tribunals that is referred to. There is no reference whatsoever to nothing else, only the other administrative tribunals, as if it was really a self-contained, completely isolated system. So I have here, these can look like a very strange series of letters and numbers, but these are references to case law. Like, first of all, I have label and reality. that refers to the two approaches that I mentioned. A label is the approach that looks at the label that you give to the legal relationship in the contract, the formal approach. If the contract says this is not an employment agreement, then this is not an employment agreement, full stop. That's one approach. And the other approach is reality, like looking at, yes, I understand that the agreement says that it is not an employment agreement, but let's look at the reality of the case. This is the other approach. As you can see, there are more decisions on label approach than on reality approach, but there are some also on the reality approach. And these funny letters, there would be the ILO 80, that's a decision by the Administrative Tribunal of the ILO, number 4045, and etc. So you see that, that there is some jurisprudence, not huge, but there is some. And there is a majority of cases saying that you have to have the formal approach, but there are also some cases saying that you have to have the substantive approach. So that was for the first bullet point. You remember that I just go back so that we remember what I'm talking about. We were here, generally recognized principles, how to find out what is a generally recognized principle. And I said you should use as a comparison, as an inspiration, what has been said in respect of Article 38 of the ICJ. And what has been said is, among other things, you can look at principles formed within the international legal system. We have just looked at them. Or you can look at principles derived from national legal system, which is what we are going to look at now. Principles derived from national legal system. Principles existing within a sufficiently large number of national legal systems. So this would be the first step. If you make a comparative research and you find out that in a sufficiently large number of national legal systems, there is, for example, the formal approach or the substantive approach, then you can go further to the next step. And the next step is the second bullet point here. These principles, they must be capable of being applied at the international level. So it is not sufficient to count the number of legal systems that have one approach and to say them, oh, well, then this is generally recognized as an international principle. No, it's not sufficient. You have also to find out whether these principles can be applied at the international level. So transposing national principles to international law means that the values that underlie a regulation that is common to numerous systems is elevated to the level of international law. And in order to do so, you have to make sure that it is adequate, so that it is a principle that reasonably can also be elevated to the level of international law. And what would these relevant principles be? Where would you find them? Well, you could find them in the national administrative law, in the national civil service law, or in labor law, general principles of labor law, generally. And this is what the decision did. The decision looked at general labor law and found the principles according to which the employer shall not abuse its position and deprive the employee of employee protection. So this was a principle that we found in a plurality of systems. The comparative exercise was based on this book that at the time was quite new. That was a restatement of labor law in Europe, which was making a lot of comparative analysis and had a lot of references to national systems of law. And what they concluded there on the basis of that comparative exercise, they concluded that there is a principle according to which there must be primacy of the facts. So it's the substantive approach and not the formal approach. And this limits the freedom of contract. So you cannot agree anything and you cannot just rely blindly and automatically on what is written in the contract. You have to look at what is the substance, what do the facts say, in spite of what the form says. This was what comes in the as a result of a comparative exercise in the European law. And in US case law, formal circumstances cannot shield from employer liability. It's less clear in the US than in Europe, but there are in the decision references to case law showing that. So on this basis, the decision concluded that there is, in a sufficiently large number of legal systems, and the reason why it's Europe and the US is that that's the area of the European Bank of Reconstruction. So that was what was mostly relevant in that particular context. So after having seen that there is this principle of the primacy of the facts, the next step is to find out whether these principles can be elevated to the international level, whether there is a transposability. And the decision is doing it on the basis of a balancing of the conflicting interests in the national sphere and in the international sphere. So in the national sphere, the conflicting interests that are resolved with the principle of the primacy of the fact, they are, on the one hand, the free exercise of entrepreneurial autonomy and the freedom of contract, that the parties can agree whatever they want. And then on the other hand, it's the protection of the weaker party, that the employee or the person who is doing the work is maybe forced by the circumstances to accept some terms of contract that they would never have accepted if they had a stronger bargaining power. But since they are the small employee, they cannot do anything else but accepting those terms. So these are the two conflicting interests that in the national principles are resolved by giving primacy to the situation of fact. And what is the international level? In the international level, the conflicting principles would be between, on the one hand, the discretion of the organization. The international organization must necessarily have organizational and managerial discretion, otherwise it would not work. And on the other hand, you have the principle of avoiding abuse of power. Avoiding abuse of power, that is a principle that you have in international law. It's not only a national principle. So having these two principles against each other in the international sphere, having seen that these two principles have to be balanced also in the international sphere, you see that it is possible to transpose the solution that is found at the national level also to the international level. So this exercise permitted to say that there is a general principle that is also applicable in an international context. So the conclusion in the decision was that there is, on the one hand, there is a presumption in favor of the wording of the contract. On the other hand, and exceptionally, the wording of the contract may be disregarded if it is a very narrow exception, and the decision goes very much into detail. We don't need to do that in this particular context, but if there is no functional justification for the arrangement that has been made, if the organization is abusing its power and depriving the employee of its protection, if there is a very clearly divergence between the situation in fact and the contractual regulation, then there may be a basis for disregarding the terms of the contract. In this particular case, the decision was negative for the employee. So all this reasoning here was to confirm the power of the arbitral tribunal to make a decision on whether there is in this particular situation an employment contract, an employment relationship, in spite of the fact that there is not an employment contract. So all this reasoning was to legitimate the arbitral tribunal's the administrative tribunal's jurisdiction on this issue. But then in the specific case, the administrative tribunal found that there was no employment relationship, in fact. So you see, of course, that you understand that there is a difference between saying that you have in theory the power to decide something and then deciding it in the particular specific case. So in this particular case, the appellant was not an employee. And this led to the conclusion. The conclusion was the decision by the panel was unanimous, but there were two concurring opinions. Why is that? Well, because on the one hand, everyone agreed on the conclusion, on the result. He was not an employee. On the other hand, the other two judges, they did not agree on all the reasoning. They thought all these things about principles and national law and public international law and so on, that was completely not necessary, because this was a self-contained legal system where the only relevant thing was what other administrative tribunals had decided, and the majority of the other administrative tribunals had decided that the formal approach should prevail. So the other two judges were actually of the opinion that we should never have taken jurisdiction here, and that it was not necessary to make all this cross-fertilization between the public international law and the administrative law, because there was no basis in any case. So this is an example. I think this was my last, yes. So this was an example of a situation where the cross-fertilization, to my mind, is desirable, but not to everyone's mind, because the other two judges, they thought it was a waste of resources to start thinking of all these other aspects, and there could a decision could have been made very quickly and simply on the basis of the jurisprudence of the international administrative jurisprudence. So that was one example. Cross-fertilization was desirable. Let's now look at another example. Cross-fertilization not desirable. And what I'm doing here, I'm showing a screenshot, I think it's called, from the Translex. Translex is a database organized by the University of Köln in Germany on transnational commercial law. Transnational commercial law, it means contracts between commercial parties, commercial contracts between parties. It could be not necessarily private parties. It could very well be a state or a public entity that enters into a commercial contract. Irrespective of who is entering into the contract would be qualified as commercial if it is a commercial contract, and not like a concession or a production sharing agreement or something else that has a public law aspect. So what this database says, so it's a database of different principles that are generally considered to be recognized in the international commercial field. And it's a soft law source. It's not a convention or anything binding at all. So it's a soft source that is written as if it was, like it's, you know, that it's quite popular. It's written as if it was a restatement of the transnational commercial law. So the first, very first article is number 1.1.1, good faith and fair dealing in international trade, saying that, stating that there is a principle of good faith. And I was very intrigued when I saw that, because I'm doing a lot of international commercial law, and I know that, and I do a lot of comparative law, and I know that good faith has so many different meanings. And first of all, you have the very well-known divide between the common law and the civil law. But then even within the civil law, where everybody agrees that good faith is important, you have many different understandings of what is the good faith. So I was very intrigued when they say that, oh, in international trade, good faith is the most important principle. So I wanted to look at the sources. Let me see what sources do they have. And these are some of the sources that are there. And you see that they have some national decisions. Well, this is the section, as you see here, this is the section of the court decisions. They also have a section on arbitral awards and so on. And in the court decisions, you see that there are some decisions are national and some decisions are international. So I was saying, wow, the ICJ? What does the ICJ say on international commercial law? And this particular one makes reference to this one here, Australia versus France. So I went and clicked and looked at what the ICJ said in Australia versus France that could have a meaning for commercial contracts. You know, probably Australia versus France, that is an old case, 1974. Not so old that I wasn't born already, but still very, 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 very old. And you may know that at that time, France was making experiments with the nuclear bomb, and the nuclear bomb is dangerous. So they were making them very far away so that they would be safe. Problem is that what is very far away from France happened to be very close to Australia. So everything is very relative. Very far away for someone is not necessarily so far away for the others. So what happened is that Australia protested, and then France said, okay, I won't do it anymore, and then they did it again. And then the case was filed before the International Court of Justice. And what the International Court of Justice, this is copied actually from this database here. One of the basic principles governing the creation, blah, 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 is the principle of good faith, blah, blah, blah. And then they say, just as the very rule of pacta sunt servanda in the law of treaties is based on good faith, so also is the binding character of an international obligation assumed by unilateral declaration. So what the ICJ is saying here is that in the public international law, if a country assumes by unilateral declaration an obligation, that obligation is binding because of the principle of good faith in international law. And this is, I'm repeating it, this is public international law. Can you really use this to say that unilateral declarations are binding in commercial contract all over the world? And a firm offer would be a unilateral declaration. In the Romanistic systems of law, I have here the Italian Civil Code as an example, firm offer is binding. Okay, so this corresponds to what the ICJ said. In the Germanic systems of law, firm offer is binding. Okay, this corresponds to what the ICJ said. In the common law systems, well, I have here the USA and England as an example. In the common law system, you know that better than I do, there is the doctrine of consideration. A unilateral offer is not binding unless there is a consideration. And of course, in the USA, you have the promissory estoppel that may render the unilateral declaration irrevocable and binding. But in England, you don't. If there is no consideration under English law, of course, they have the theory of, we are not talking about English law here, but the point, there are a lot of restrictions to the theory of consideration, but the general point is still that under English law, a unilateral offer is not binding. So which is exactly the opposite of what the ICJ had said here. Binding character of an international obligation assumed by unilateral declaration. But the ICJ is not saying something wrong because they are talking of international obligation. So in international level, unilateral declarations are binding. But if you have a commercial contract governed by English law, as many contracts are, then the theory of the doctrine of consideration leads to the conclusion that the unilateral offer or declaration is not binding. Does that mean that England is in breach of public international law? Of course not. It simply means that there are different spheres. ICJ was talking of public international law. English law of contracts regards contracts, commercial contracts, private contracts. So they are different spheres, and it is not necessarily possible to cross-fertilize. I have here a a chart on good faith, which is of course very, very simplifying, and we don't need to go through that. I already told you that in the civil law, you have an understanding of what good faith is, which is quite large and extensive, and can even create duties and rights between the parties, in some systems more than in others. German law, Norwegian law, they have a very extensive duty of loyalty. In other systems, they have less. But in the common law, you have actually no general principle of good faith. And of course, I know that there are now, particularly Lord Legat is very interested in good faith, but even he, who is actually the champion of good faith, he is now in the Supreme Court, I understand, after having been very shortly in the Court of Appeal. So even he, who is the champion of good faith, he says that good faith is a modest requirement. It does not require to have regard to the other party's interests. It can be derogated from by clear terms of contracts. It cannot be used to imply terms in a detailed contract. So it is a completely different requirement from what you have in the civil law. And this is why am I saying that? Not because we are making a course on contract law or comparative contract law, but to show that a simple, not a simple, a very important declaration made or consideration made by the ICJ on public international law does not render the principle of good faith binding also in the international commercial legal system, because in commercial law, contracts are regulated by national laws, and national laws have very different approaches. So good faith in international trade, is it a general principle? Can you rely simply on similar sources like the ICJ decision to say that there is a general principle? No. Can you say that it is a generally acknowledged trade usage? Very difficult, particularly if you look at one of the most important sources of usages, which is the contract practice. Contract practice is undoubtedly in international contracts based on common law style. Contracts are written in the common law style. Contracts are written responding to the understanding of contract law that you have in the common law, which means that the good faith is a modest requirement, if at all it exists. And then in this database that we have now just seen, good faith is deemed to be a general principle. It has as sources arbitral awards that if you go and look at them, you see that they do not really give a specific standard that permits you to understand what is actually meant by good faith. They make reference to the 1980 Vienna Convention on the Contract of Sales, which interestingly does not have good faith as a duty between the parties. It only has good faith as a standard for interpreting the convention. You have these decisions by the ICJ and other public law decisions. And then the interesting thing is that you have the unidroit principles, the principles of European contract law, as possible sources to give you an understanding of what is the scope of the principle of good faith. But if you look at the unidroit principles, they will tell you that the principle of good faith has to be interpreted as it is interpreted in international commercial law. But in international trade. But in international trade, here we are back to this, it's a vicious circle, you see. The database that translates tells you have to go and look at what the unidroit principles say, and the unidroit principles say you have to go and look at what the international trade system says. So they are referring to each other without really giving you a specific standard that you could base your decision on. So is it possible to have cross-fertilization in this context? Unilateral promise is not binding under English law. Does this mean that the English law is infringing the principle that has been set by the ICJ? And the only reasonable answer is to say no. The ICJ was speaking about public international law, and English law of contract regards contracts. So they are simply two different spheres. It is not possible to have cross-fertilization in this field. So, and this is, I think, my last slide, I think, I'm not sure. You remember that I showed at the beginning the Commission on the ICL, the Commission on International Law. So they said that fragmentation is, well, they had a report on fragmentation, and then they had a conclusion on how to cope with this fragmentation. And I think it was 42 different conclusions on how to interpret international law in this fragmented picture. And they have, you see at the end, I have ... here, because there are 42, and I only took those that I thought prima facie were most relevant. They say international law has to be looked upon as a legal system, like my drawing at the very beginning. It was the blue bubble within which the other colored bubbles were. It is one legal system. It should be considered unitary. So there is a principle of harmonization. You should try to harmonize the sources within that legal system. However, you have the principle of lex specialis. And of course, when to apply the lex specialis or when to apply the harmonization is a question that requires a contextual appreciation. And of course, self-contained regimes, they may have an important role. In some situations, there may be very good reasons for having an isolated regime that has only its own rules. In other situations, there may be reasons for cross-fertilization among the different regimes. You have systemic integration issues, general principles, lex posterius issues. You have many different mechanisms of interpretation that you can use for the purpose of obtaining a reasonable solution. The whole point is that you do not have one way of dealing and coping with fragmentation. It will be necessary to do, as we have seen in these two examples, it will be necessary to understand what are the underlying interests, to understand what is the balancing between the possibly opposing interests, and to see whether it is possible to transpose a solution from one system to another. So everything depends on the contextual appreciation of what you have. You cannot have one automatic answer. So I think this was my last slide. Yes, it looks like it was my, let me see if I can, well, it was my last slide. So someone who understands this better than I can go back to whatever screen is needed. But thank you for your attention.
Thank you very much, Professor Cordero-Moss, for illustrating so well both the case for cross-fertilization, but also the case where you mentioned that sometimes in the context of a specific situation, it could be undesirable to have cross-fertilization. Yes, very interesting. I fully agree with the second part of your presentation, that there could be a different circles of law that should not really duplicate, they should not cross, because if a principle applies to public international law, it applies to public international law. So the contract law should not be able to apply principles that are adopted in this case by ICJ in France, Australia, in a different part of law, not in the contract between two trade units. But also, I was very interested in your first part of your presentation, the dispute between a contractor in EBRD and the administration of the EBRD. And here I have a little bit of problems with the decision of the tribunal when they said that there is no employment relationship. Obviously, there was no employment contract, but I would ask what other relationship was that person with EBRD apart from being in some sort of employment relationship. It was not a friendship. It was not a slavery relationship. It was not a sexual relationship. The only relationship that person with the tribunal was actually an employment relationship, although not fixed in a contract. I think the person had a good argument that as far as there is no other relationship, the only relationship between EBRD and that person was an employment. And in fact, the EBRD wouldn't be able to challenge that. They were paying him or her, and they're asking him or her to do some tasks, which in every understanding is an employment relationship. By the way, in India, a lot of people do work like that. There is a lot of informal labor. I think some even say 70% of the labor in India is some sort of a relationship, which is not fixed in a proper contract. But that doesn't mean that the employer and the employee are not in an employment relationship. So I have a bit of a problem with that judgment, although I would recognize that the person has no point to demand any payment here. It was not fixed initially when the person joined the EBRD, so there is no point to satisfy the demand for payment. But at least the tribunal should have acknowledged that the only relationship between EBRD and the person was an employment relationship. But also,
can I answer? Can I answer that?
Thing. Yeah, go ahead.
Yeah, thank you. I agree with what you're saying. And everything is very much based on the facts of the situation. So in that particular situation, the contract and the relationship was a relationship for the provision of services. So it was a service contract. And why did the tribunal come to that conclusion? Because it saw that the service provider, so the appellant, the contract that had been entered between the bank and the service provider provided for a higher degree of pay than if the person had been an employee of the bank. And the higher degree of pay was justified with the fact that this was an independent service provider who would have to enter into its own insurance, save money for his own retirement plan, and make provisions in case he was sick. All these things that normally are covered by the employer, they were not covered in this contract, and therefore the level of pay was higher to provide for this. So the point was that he enjoyed, but this was very much based on the facts of the case. And it was actually proven that it was not only a question of considering, oh, that was a very high salary. No, it was actually shown and proven that the salary was covering also all these aspects that normally would have been covered by an employer. So that was, in the eyes of the tribunal, sufficient to say that this person here was working as an independent service provider.
Absolutely. I don't challenge any of that. That's absolutely true. Actually, I did work for United Nations in Tokyo, in the United Nations University, and we did hire many people, which we shouldn't probably, but personal service agreement was exactly providing of services on a high hourly pay. And these people are supposed to save for their pensions or for their sick leaves. I understand very well that contract. But again, we treated those people as employees. They were part of every gathering, of every Christmas party or Easter party, that they were contributing actually to the staff fund as to benefit. And again, staff fund is about staff. These are not properly staffed, but they were part of the staff management committee even. They had a representative sitting there as well. But one problem when institutions hire people on services agreement is exactly that could be abused. And that, back to the point you made, that the employer should not abuse a contract in a way to avoid hiring in a proper context. So basically, what in one situation, the staff management committee, it's basically a body that adjudicates tensions between staff and management, said that only if the employer, the United Nations, have a very compelling case to recruit people under service agreement, they should do so in a very minimal and very justifiable context. They shouldn't go very much into that channel because it will create long-term tensions between two parts of employees, full employees under the UN regulations and service agreement contractors. And actually, the United Nations Administrative Tribunal in New York also dealt with such situations where United Nations, some parts of the United Nations actually did abuse the possibility to hire on personal services agreement. Quite interesting. My other point is about what you mentioned, and I fully agree with this. Article 6 of the European Convention on Human Rights is a very strong moment for fertilization, if you want, because the right for fair hearing and fair trial is quite interesting. We discussed this in a different context with the Security Council Resolution 1373, establishing a counter-terrorist regime, which actually lists some individuals as being related to terrorist activities, and accordingly they fall under the sanctions of the United Nations Security Council. Normally, we assume that the Security Council is the most powerful body in the world, and that's what the United Nations Charter says. That's what public international law says. But interestingly, in a few examples, I remember Cadi case, where the European Court of Human Rights, but even domestic courts, can challenge a decision if it goes against human rights violations. So I would kind of to ask you whether I would argue that human rights law should be applicable, let's put it this way, should be fertilized any other parts of the law. So there is no, even the most force majeure situation, a Security Council decision under the threats to international peace and security, to imagine Chapter 7 situation, should never reduce the individual human rights. So human rights law should be applicable in any situation, no matter what jurisdiction, no matter, and my question is, can you think of an undesirable fertilization when one part of this is the human rights law? I cannot imagine a negative fertilization when one of the law will be a human rights law.
The primacy of human right of human right law is a well-known principle that actually, to a very, very large extent, I agree with. However, there are nuances because, for example, within the International Commercial Arbitration law, there is a debate when human rights lawyers get acquainted with arbitration or commercial arbitration law. They say that, oh, but an arbitral award should be set aside, or enforcement should be refused also if it is in violation of human rights. So they want to have an additional reason for refusing enforcement or setting aside an award. And my point is that I agree that human rights are extremely important, that human rights, violation of human rights can very well be a basis for setting aside an award or for refusing enforcement. But it does not necessarily need to be a separate additional basis, because in the New York Convention and in all the national laws, you have rules on public policy. If the award is against public policy, it can be set aside or it can be refused enforcement. And the human rights, necessarily, they are a part of the public policy. So I don't think, so I agree with the principle that human rights, they are in most of the situations. Now, I can't say always because I don't really know everything, but in most of the situations, I would say that yes, human rights, they enjoy primacy. But they do not necessarily need to do that in their own separate additional way. It can be incorporated into the mechanisms that already exist. Like, for example, the public policy exception for arbitration.
Thank you. I had one interesting example in my career when in the bombing of Yugoslavia in Kosovo in 1999, which was part of an armed conflict. So international humanitarian law does apply. And one victim of that bombing of the Belgrade TV station, Bankovic, died. The person was there during the night when NATO bombed that station. The family, the relatives, wanted to apply the jurisdiction of the International Criminal Tribunal for former Yugoslavia, which is a perfect jurisdiction because it is applicable to any violation of international humanitarian law in former Yugoslavia, but they were not successful there, apparently because international humanitarian law is lex specialis. In a way, it applies in time of war, but for that matter, to prove violations, you need a higher threshold. But when the case was not successful in ICTY, in the International Criminal Tribunal, they did the same in the European Court of Human Rights. They apply Article 2 right of life in the European Court of Life, and they were successful there. So human rights courts have a better chance for appellants, in this case particularly, exactly because in time of war, you need a higher threshold of proof that it was not military necessary to bomb that target. But in the human rights law, you can have a larger opportunity as an appellant to prove a violation of right of life because it is a more applicable and more understandable among the judges. But anyway, let's move to more questions and comments from our audience. Again, Akriti, can you moderate that? If you see some hands up, I will try to do the same on my screen. Yeah.
Any questions from the students? Anyone?
Yeah, I wanted to ask one question with regards to this apparent tension between civil and civil law and common law, and how do you reconcile this tension between them? Because vis-a-vis a situation of fragmentation of the jurisprudence that you see in these international tribunals, because in common law we've got this system of precedence, whereas in civil law you don't have this system of precedent, and the decision is only binding in to the parties of the case. So if you have this kind of a tension which is inbuilt in civil law, how can you then apply common law jurisprudence to these cases? Also, how do you reconcile fragmentation to this aspect? Is a question.
Well, the area where I see, if we're speaking about contracts and commercial relationships, the area where I see most tension between the civil law and the common law is the interpretation of contracts and the role of the good faith and the way in which the judge interprets the contracts. That is really a question, a source for very, very serious tension. The fact that you have precedents in the common law and that you have written statutes in the civil law does not really create a difference from, of course, it does create a huge difference from the point of view of constitutional law or from the point of view of state law, but from the point of view of commercial law, you are relating to the sources, whatever they are. They can be a decision of the Supreme Court or they can be a statute. It doesn't really matter so much. So I don't see that as a ground for difficulties in the commercial law. What I find interesting is that this system of precedents that is typical of the common law is very widespread, as you know, in many different areas of international adjudication, not only where you would expect it, like you have, of course, the ICJ takes into consideration its own jurisprudence. International administrative tribunals, they take into consideration the jurisprudence of other administrative tribunals. That can be expected. It is maybe not a codified, formalized system of stare decisis, but it is de facto. It is one. It works. It's very desirable. What is interesting is that you have the same approach to the value of precedents in other areas where you would not expect it, like, for example, investment arbitration. In investment arbitration, all the awards make very extensive reference to all the other awards, and now there are so many, so it's really a long exercise. And that you would not expect, because you would expect that a permanent court takes into consideration and prizes the consistency of its own jurisprudence. That you understand. Or within a specific legal system like the administrative tribunals. But investment arbitration, it's ad hoc, even when it is institutional, it's tribunals that are being elected only for, its panels that exist only for that particular dispute, so they are not a permanent court. And they may be acting under very many different treaties. So it's not necessarily the same law that they are applying. They are applying, of course, the general investment law, but then they have a treaty between Norway and Russia, and the day after, another tribunal has a treaty between the US and Canada, and yet they are taking each other into consideration, or the latest award takes into consideration the former award. That is very interesting, I think. It's very desirable, of course, because it permits to create an organic, consistent, in theory at least, body of law that otherwise would be extremely fragmented. Now, we know that in practice it's not always very consistent, but the method of giving consideration to all the other decisions that have been taken, even if they are based on different treaties, that is a very desirable method.
Thank you. Thank you.
I see we're already 90 minutes into our talk. I wonder if there are more questions. Akriti, yes?
Professor, I just had one observation. Thank you, Professor Moss and Dr. Popovski, for such a wonderful lecture. Adding to Dr. Popovski's observation, this is one thing that I've noticed in investment arbitration, as you very rightly mentioned. A lot of criticism for investment arbitration that has generally been brought forward is that this was something that we were taught by, or we were discussing in, our lectures earlier, that as a practitioner, when you have to design investment claims, and you have to verify the success or the failure of an investment claims. So a lot of investment tribunals do not entertain pure human right claims. They have denied jurisdiction on the basis of that this falls beyond our purview. So a lot of practitioners, or the observation that they make is that you have to disguise human rights claims and interlink it with a part of the investment treaty or the investment contract, and then maybe you can hope for some success. That is something that one has observed. The other thing in terms of the norms and the principles of international law, this was something that was said in our earlier lectures, that this distinction or fragmentation is more of an academic let's say discourse. But the other perspective that a practitioner as well as professor, as an academician, I've noticed is that some people say that this distinction of primary and secondary norms in international law is it's not of much value in terms of furthering discussions or developing literature. It just complicates the narrative. So I just wanted your observation from Dr. Popovski and obviously from Dr. Moss. What is your perspective? That I understand that self-contained regimes do arise, and they have their practices. But in terms of norm creation and this designation of primary and secondary, is that a valid criticism, or is it required? This is something that I wanted to understand.
Okay, Giuditta, do you want to start, or shall I answer this?
I don't know, the question was to you and me, so you can go ahead.
And actually my course is called United Nations Law, so let me quickly tell you that it could work either way here. On one, in a book which I wrote 7 years ago, it's called Security Council as Global Legislator, we look at what we call the country-specific and thematic resolutions of the Security Council. So traditionally, the Security Council only adopted country-specific resolutions, meaning if a country violates international law, there are sanctions under Chapter 7 and so on. But in 1999, there is a new development, and the Security Council began with what they call thematic debates and thematic resolution, addressing a problem as such globally, no matter which country does what. And this was, as you know, the counter-terrorist resolution, which I mentioned earlier with the challenge in the European Court of Human Rights. CADI case was exactly a result of the resolution, which is a thematic one, 1373, by the Council, establishing a legal regime. In other words, it's a kind of a legislating, in other words, not the member states approving conventions and treaties, but the Security Council using the power of Chapter 7 to basically enforce or create a legal regime, which all countries in the world are actually obligated to respect and to implement. And now, in that book, we were asking whether one can influence the other or fertilize the other. Can the thematic resolution be useful in a future country-specific situations? And we hope so. It doesn't have much proof so far, but our expectation at the time was that indeed it should work this way, in a sense. If a new regime is created, no matter which country does what, that should be applicable. So in a way, I was very happy to see, for example, themes such as protection of civilians, children in armed conflict, developed as thematic resolutions, because effectively what the Security Council was saying is that in any place around the world, if children suffer in armed conflict, if women are discriminated, if civilians are maimed or raped, that regime, that creation of the Security Council should be applicable. So either way, doing global imposing, as you say, you're asking how norms will develop. Imposing global norms and then applying them to country-specific situation is a very good, I will argue, model, but also the other way around, taking the specifics of a very fragmented regime, as, by the way, the lecture today, Professor Cordero-Moss very well explained, linking fragmented parts of the law in a comparative manner is absolutely essential as to understand the context, as to understand the substance, not simply to look at the form of the law, but also at the substantive part of the law. And that's actually what happened. The thematic resolution of the Security Council were a result from specific situations. They ended up by writing that resolution, having in mind what happened in Afghanistan, in Libya, in many other country situations where terrorist acts were defined as threats to the peace, and the Security Council adopted sanctions under Chapter 7 against Libya, against Sudan, against Afghanistan. So taking from the specific, you create a global regime. And you expect that later, and it is exactly the International Criminal Court. Remember, there were ad hoc tribunals for Yugoslavia and Rwanda, specific tribunals for one territory or two territories for a specific time. But then you have a permanent International Criminal Court, so you don't create anymore those ad hoc tribunals because you have a permanent court, and any situation should go to the permanent court. And then, exactly, next time, if something happens in country X, Y, and Z, you apply the global regime. That's my comment or observation to your observation.
Yeah, if I may, I can't add because I think this is an incredibly interesting and insightful observation. But if I can address the question from a slightly different point of view, you're asking whether the division into primary and secondary norms is useful, and I am very, although I am originally an Italian lawyer, so I'm very interested in all these theoretical systematic questions and so on. In spite of that, I have been living for more than 30 years in Norway, so I'm very influenced by the Scandinavian realism. And to my mind, the category between primary and secondary norms is a description of, it's a way of systematizing the world, the legal world, and it can be useful to the extent it is useful, to put it that way. So if you need it for explaining some legal effects or something, then it is useful. Otherwise, if it is only something that you have to learn for the purpose of knowing, of course, it's always useful to know what is being said, but if it does not reflect some legal effects, underlying legal effects, then it is not very useful. But of course, this applies to all the categories, because just building on what was just said about sometimes you have norms that, according to their formal label, would not have a certain legal effect, but in practice they have it. So this question of the categories is not necessarily always very useful. To the contrary, it can actually confuse the picture.
Thank you so much, Professor. Thank you so much.
Thank you. Thank you. It was very informative and wonderful to see you, Giuditta, with us today. And thank you, Ankit, for organizing the meeting today, and generally to organize the General Society for International Law and bring such excellent speakers to us.
Thank you so much. Would not have been possible without your constant support and guidance. Thank you so much, Professor, for coming and sharing your thoughts with us. Grateful and highly obliged. Thank you very much.
Thank you very much. It has been a pleasure, and I make you all my best wishes for the future to all of you.
Sure, let's stay in touch.
Thank
Let's
you.
hope to see you in campus one day the travel is allowed. We want to invite you to our Best in India #1 Jindal Global Law School.
That would be wonderful. Let's first hope that the emergency is overcome. That's and I absolutely, I would love to, and let's stay in touch.
Sure. All the best to you.
Thank you. You too. Bye,
Professor.